move to public comment. The name of the board member will appear in the bottom left-hand corner of your screen. For instance, this is board member Y, and this is board member E. Public testimony will be accepted at the beginning of the meeting and before each agenda item. You can indicate that you are ready to testify by clicking on the raise hand button being circled by the mouse on your screen now. At the appropriate time, the board will recognize you to speak and ask you to unmute your mic as shown here. Again, public testimony will be accepted at the beginning of the meeting and before each agenda item. Public attendees will not be able to unmute their microphone until recognized by the board. Public attendees who are recognized to testify will be asked to identify themselves by name and their affiliated organization if applicable. Please mute your microphone when you are finished speaking, and as a courtesy to others and members of the board. Public attendees will not be able to unmute themselves after the testimony is completed unless recognized again after raising their hand. At some point during the meeting, the board may choose to move into executive session. When the board moves into executive session, the board members' microphones and video feeds will be turned off, and a similar screen as you see now will be displayed. When the board returns from executive session, their microphones will be turned on as well as their video cameras. Welcome again to the Professional and Vocational Licensing Virtual Board Meeting. At this time, the chair will call the meeting to order and take a roll call, as well as explain any additional rules that may be specific to this board.
Right, so hopefully y'all can hear me. I'd like to explain a few more rules related to this board. So as far as internet access, just to reemphasize, to view the meeting and to provide live oral testimony, please use the link at the top of your agenda. You'll be asked to enter your name, and the board requests that you enter your full name, but you may use a pseudonym or other identifier if you wish to remain anonymous. You will also be asked for an email address, and you may fill in this field with any entry in the customary email format. For example, a username, the sign at, and the email domain, generally the emaildomain.com. Your microphone will be automatically muted. When the chairperson asks for public testimony, you may click the raise hand button found on your Zoom screen to indicate that you wish to testify about a specific or particular agenda item. The chairperson will individually enable each testifier to unmute your microphone, and when recognized by the chairperson, please unmute your microphone before speaking and mute your microphone after you finish speaking. For those of you who are accessing the meeting via phone, if you cannot get internet access, you may get audio-only access by calling the Zoom phone number that's listed also at the top of your agenda. Upon dialing the number, you will be prompted to enter the meeting ID, which is also listed at the top of the agenda. After entering the meeting ID, you'll be asked to either enter your panelist number or wait to be admitted into the meeting. Note that you will not have a panelist number, so please wait until you're admitted into the meeting. When the chairperson asks for public testimony, you may indicate you want to testify by entering the star sign and then the number 9 on your phone's keypad. After entering the star sign and then the number 9, a voice prompt will let you know that the host of the meeting has been notified. When recognized by the chairperson, you may unmute yourself by pressing the star sign, then the number 6 on your phone. A voice prompt will let you know that you are unmuted. Once you have finished speaking, please enter the star sign and then the number 6 again to mute yourself. For both internet and phone access, when testifying, you will be asked to identify yourself and the organization, if any, that you represent. Each testifier will be limited to 5 minutes of testimony per agenda item, and if connection to the meeting is lost for more than 30 minutes, the meeting will be continued on a specified date and time, and that information will be posted on the board's website, which you would have available to you on the agenda. Similarly, instructions to attend the State of Hawaii virtual board meetings may also be found online at the DCCA-Hawaii.gov site specific to the Hawaii Medical Board. And so at this time, I'd like to call the meeting to order. And so if you could please let me know if you are present and alone. So I'm Danny Takanichi, Oahu member, current chairperson. I am present and alone. Mr. Gary Belcher.
Present and alone.
Dr. William Hatton.
Present and alone.
Dr. Elizabeth Ignacio.
Present and alone.
Dr. Michael Jaffe.
Present and alone.
Dr. Angela Pratt.
Present and alone.
Dr. Rick Fong.
Present and alone.
And Dr. Jerry Young.
Present and alone.
Did I miss anyone? Okay.
Chair, Wesley, Mr. Mann is excused from today's meeting.
Okay, thank you very much for that. All right, so before we proceed with the meeting, is there any public testimony? And just as a caveat, any individuals for whom their license applications are going to be discussed, we will invite you into our executive session. So with that caveat, is there anyone who wants to provide any testimony before we move forward with our meeting?
Thank you, Chair. This is Johnny. We do not have anyone requesting to provide testimony.
Thank you, Mr. Lee. All right, so the next item on the agenda is the approval of our minutes. And currently, we don't have the January 2025 executive session minutes. So if I can entertain a motion for approval of the prior minutes, with the exception of the executive session from January.
Belcher, motion to approve the December 12th, 2024 executive session minutes and the January 16, 2025 open meeting session minutes.
I'll second.
Okay, thank you. So moved and seconded. Any further discussion on those minutes?
Dr. Takanishi, I would be abstaining from January meeting minutes since I wasn't present.
Okay, so let me do this, if it's okay with you. Our first and second, let me count to be sure. Okay, we'll still have quorum. So I'll take them separately because I too plan to recuse myself from the December minute. Since I was also not present at that meeting, I would abstain. So if I could entertain a motion separately, if you will, I guess Mr. Belcher and I think it was Dr. Young, for the December 12th, 2024 executive session minutes, we'll take them separately.
Sure. Motion to approve the December 12th, 2024 executive session minutes.
Okay, is there?
Second.
Thank you, Dr. Young. Any further discussion on the December 12th, 2024 minutes? Okay, and so I will do a roll call. And so Danny Takanishi, Oahu member, I will abstain. Mr. Gary Belcher?
Approve.
Okay. Dr. William Hatton?
Approve.
Dr. Elizabeth Ignacio?
Approve.
Dr. Michael Jaffe?
Approve.
Dr. Rick Fong?
Approve.
Dr. Angela Pratt?
Approve.
And Dr. Jerry Young?
Approve.
Okay, so it passes. I do see a hand up.
It looks like one of the applicants.
Hi, yes, sorry, it took me a minute to figure out how to raise my hand, but I am here and I do want to speak when I have an opportunity in the executive leave.
Okay, all right, fine. So thank you for that. And so we're still on agenda item 2, the approval of the minutes.
It looks like there's a second applicant also on the current meeting.
Okay, and again, I'll just reemphasize that for those whom their applications are being considered at this meeting, we will be inviting you into our executive session to provide your testimony. So you may choose to do it then, or you may choose to do it in open session. But right now, we're going to continue just to complete agenda item number 2. Okay. So the second component, agenda item 2B, if I can entertain a motion to approve the January 16, 2025 open session meeting minutes.
Pratt. Motion. Ignacio, second.
Okay, so moved and seconded by Drs. Pratt and Ignacio. Any further discussion? Okay, I will take a roll call on that. Danny Takanishi, Oahu member, I approve. Mr. Belcher?
Approve?
Dr. Hatton?
Approve.
Dr. Ignacio?
Approve.
Dr. Jaffe?
Approve.
Dr. Fong?
Abstain.
Dr. Pratt?
Approve.
And Dr. Young?
Approve.
Okay, thank you. Did I miss anyone? Because I'm looking at my screen.
You got everyone.
Okay, the motion carries. So now, what I would like to do is entertain a motion to go into executive session.
Jaffe, so moved.
Okay, thank you, Dr. Jaffe. Is there a second?
Second, Hatton.
Okay, thank you. All those in favor, please raise your hand. It is unanimous, so I will not do a roll call, and we will now enter into executive session. Okay, we're now in open session, so I'm just waiting to be able to see all members of the board. All right, so I'm going to do a quick roll call. So I'm Danny Takanishi, one of the Oahu members, current chairperson. I'm present. Mr. Gary Belcher,
Present.
Dr. Andrew Fong,
Present.
Dr. Brian Hatton,
Present.
Dr. Elizabeth Ignacio,
Present.
Dr. Michael Jaffe,
Present.
Dr. Angela Pratt,
Okay.
Dr. Rebecca Sawai, I did see her. Okay. Dr. Sawai, are you able to turn your video on? Um, Dr. Jerry Young?
Present.
Okay. And the minutes can reflect when Dr. Sawai is able to enter the open session. But we do have quorum, so I'm going to proceed with the business of the board. So the first, we'll be going to the applications. So make a motion on the first, on the application of Dr. Bowling. I would move to defer the application pending a receipt of additional information that the executive officer will seek to obtain from the applicant. Is there a second? Okay, Dr. Pratt, I see your hand up. Okay, all right, so seconded by Dr. Pratt. Any further discussion? Okay, all those in favor, please raise your hands. All right, it is unanimous, so I won't take a roll call. If I can entertain a motion on the matter of the application of Dr. Amy Ellingson.
Elizabeth Ignacio, I move to approve application of Dr. Ellingson.
Okay, is there a second to the motion?
Second, Young.
Okay, thank you, Dr. Young. Any further discussion? All those in favor, please raise your hand. Okay, it is unanimous, so I will not do a roll call. If I can entertain a motion on the matter of the application for Dr. Michael Maruska.
Dr. Mike Jaffe, I move to accept Dr. Michael Marushka's application for Hawaii medical licensure.
Okay, is there a second?
Patton, second.
Okay, thank you. Any further discussion? All those in favor, raise your hands. It is unanimous, so I will not take a roll call. And then on the matter of the application of Dr. James Teat, if I can entertain a motion.
This is Brian Hatton. I make a motion to approve his application for Hawaii licensure.
Okay, is there a second?
Jaffe, second.
Okay, any further discussion? All right, there being none, all those in favor, please raise your hand. Okay. It is unanimous, so I would not take a roll call. And now if I can entertain a motion to approve the ratification list before you.
Ignacio, so moved.
Okay, thank you. Is there a second?
Young,
Second.
Okay, thank you. Any further discussion on the ratification list? Okay, there being none, all those in favor, please raise your hand. Okay, all right, so so the motion passes unanimously, and so we're going to move on. And then the minutes reflect that Dr. Sawai was, looks like was able to join the open meeting. Okay, so moving on to the legislative session, I think there are, you have before you some of the testimony that was provided by the executive officer on behalf of the board. And so there's only two bills that I'd like to solicit input from members of the board. And so one of the bills involves SB 1243 relating to foreign medical graduates, along with the companion bill for that. And then the other one has to do with the HB 1379. And I don't think in our packets we have the companion bill, but that has to do with the licensure of foreign or international medical graduates. And so, you know, given the recent press release and guidance provided by the National Advisory Commission on Alternative Licensing Models, now that we have some additional guidance in looking at pathways for licensure across the United States for international medical grads, I'd like to, I think, entertain a motion from the board as to what the board's will is in terms of the disposition of those two bills, inclusive of their companion bills, related specifically to licensure of foreign medical or international medical grads. In terms of would the board be in support of that? Would the board be opposed to these, or would the board choose to defer or ask that these bills be deferred for the current session? And so at this, I'll entertain a motion now.
This is Gary Belcher. Motion to defer these bills based upon information that we've received from the FSMB Support Advisory Commission, releasing recommendations to inform legislators on licensing internationally trained physicians.
Okay, thank you. Is there a second? Dr. Young, you have your hand up?
Second. Thank you, Gary.
Okay, any further discussion? Okay, all those in favor, please raise your hands. Okay, it looks unanimous, so I'm not going to take a roll call. And then before you, there's a number of current bills that the board had been asked to weigh in on for the 2025 legislative session. And I will make note that for all of those bills, while we may, as private citizens, provide testimony, in terms of the board's statutory requirements or limitations, if you will, none of those would technically, aside from the bills that we've already discussed, fall within, other than the sex offender bill, for example, for which testimony has been provided, and the informed consent bills, none of these other bills fall within the board's statutory authority. And so I will leave that simply for informational purposes. At this time, I also do want to open it. Is there anyone from the public that would like to make a comment or provide any testimony on any of the matters that related to the 2025 legislative session?
Thank you, Chair. We do not have anyone requesting to provide testimony.
Okay. All right, thank you, Mr. Lee. So moving on in our agenda, item number 5, board member orientation. I'd like to turn this over to our Deputy Attorney General.
Thank you, Chair. You have some materials included in your packet. First page is the Hawaii State Ethics Commission, and this pertains to you. Board members are similarly treated as state employees. And does anyone have any questions on the first 3 pages? The next page is a flow chart entitled Disciplinary Process for Administrative Boards. And this is pertaining to existing licensees. And for new members, it's complaint driven. If there's a complaint against a licensee, that is handled by the Regulated Industries Complaints Office. They file on the left-hand side a complaint. It's investigated by RICO. If it has any merit, it's referred to the legal section, and the legal section can close it if they find no jurisdiction or insufficient evidence, technical violation where they just issue an educational, a letter of education, or they advise the complainant that maybe a civil remedy is more appropriate. They can reach a settlement agreement with the doctor or the licensee. And sometimes you see that in the form of a petition, pre-petition settlement agreement, in which they don't have too much information because the doctor or licensee wants to keep the allegations out of the public domain. All of these documents would be considered public documents if they are accepted and approved by the board. So the advantage to the doctor for a pre-petition is the less information in the public domain, the better. Of course, this also gives the board reviewing the petition or reviewing the settlement agreement less information too. And that may be sometimes frustrating to the board because they want to know more facts and information. Sometimes you may see a post-petition settlement agreement that has a little bit more information than the pre-petition. It actually has a petition where RICO sets forth the allegations and charges against the doctor or licensee. But again, because it's a settlement agreement, it's negotiated document between RICO and the doctor. It may not have all the information that the board seeks. In the case of settlement agreements, the board can only accept or not accept the settlement agreement. If they don't accept the settlement agreement, RICO can choose to not pursue the doctor and may just drop the case. They may choose to try an amended settlement agreement, or they may proceed to hearing if they think, the case still warrants discipline on the doctor. Those contested case hearings are heard by hearings officers at the DCCA. They're administrative judges. They hear evidence, testimony from live witnesses, pleadings, arguments, opening and closing arguments, and they issue a recommended order with findings of fact, conclusions of law, and recommendations. Those documents you can modify. So if it has more information, you can seek to modify the conclusions of law, in which case you would need to look at all of the evidence presented at the hearing, or the conclusions of law, or you can modify the sanctions. And after that, the hearings office takes post-petition pleadings from either party. They can file exceptions to the hearings where they disagree with parts of the recommended order, or they can take statements in support, in which case one party supports the recommended sanction and adoption by the board. Either party can also ask for oral arguments, and I think we've had that case a couple of times where the doctor and their attorneys appear before the board, and then you can issue an order either adopting the recommended order or modifying issuing a proposed final order in its place. And again, if we're getting to the board's final order, proposed final order, there can be exceptions, statement in support, or oral argument on that proposed final order. After all of that due process, the board issues its final order, and that the doctor or RICO may appeal to circuit court. So that's the whole disciplinary process of existing licensees. Are there any questions on that process? If not, the last page is entitled Board or Commission, and it has 3 ovals and basically 3 columns. So the board is basically like a government. They have an executive branch, legislative branch, and judicial branch. And the executive branch, which is the majority of your agenda, is subject to the Sunshine Law, Chapter 92 under Hawaii Revised Statutes. It's open to the public. That's where you do all your minutes, your voting and the open session minutes. You have 5 exceptions, or mainly 2 exceptions under HRS 92-5, where you go into executive session. That's to consult with your attorney or to evaluate personal information relating to applications. There are the 2 standards for considering convictions are whether the convictions are rationally or directly related to the profession. And the second factor is sufficient or satisfactory evidence of sufficient rehabilitation. And those are the 2 main factors you look at when evaluating applications. So that's all under your executive branch hat. The middle oval shape is rulemaking, where you do legislation through administrative rules. And the 3rd column is judicial hat, which is where you do take disciplinary action against existing licensees, like I explained on the flow chart on the prior page. So that's not subject to Sunshine, and that is strictly adjudicatory. Minutes don't have to be taken, and your deliberations, like a judge or a jury, those considerations and deliberations are not open to the public. Any questions on your civics lesson 101? I think Chelsea also included in your packet sunshine law options for how to deal with special projects or legislative issues, and basically they're permitted interactions of members pursuant to HRS 92-2.5, and 2 members of a board can talk to each other relating to board business, so long as no commitment to a vote is made or sought, and the 2 board members do not constitute a quorum, which it would not in your case. Or you could also do a permitted interaction group where 2 or more board members are assigned to investigate a board matter, come back to the board, report on its findings, and that a subsequent meeting, the board can act on that subject matter. And there's a couple of other exceptions under HRS 92-2.5 for permitted interactions, but those are the 2 main ones. And if you have any special project or, want to investigate a matter, you could use those provisions. Any questions on permitted interactions and the Sunshine Law? Okay. Chelsea, did I miss anything? You want me to cover anything?
Sorry, I was waiting to get unmuted. Just, I guess if we're presenting testimony, if it's personal and not on behalf of the board, just having those hats.
Right. That should be made clear in the testimony, written as well as oral. And as Danny was mentioning at the beginning of the meeting, if it's on your personal letterhead or it's on behalf of HMA or whatever advocacy group hat you're representing, in that private capacity, it's clear. And so it does not overlap, with the board member hat. And so you may be a board member, but you're speaking and testifying on behalf of your private capacity. And a caution to testimony that references private or confidential information that is considered before the board, that should not be included in public testimony, because until an application is approved, and in cases where it's not approved or just deferred, that individual has his or her privacy interests. So the details, even if that name is not identified, should not be included from the board's deliberations in public testimony at the legislature.
Sorry, question. If we're testifying as individual physicians, are we allowed to mention that we're on the board even though we are not representing the board?
I think, a sentence, I don't think it should be the first sentence, and I think it should be made clear that you're on your letterhead, on your time, and not speaking with reference to the medical board's deliberations or considerations of applications.
Yeah, I think that's the key thing, because again, it's, a lot of this is also, beyond what the law, the thresholds of the law, it's the public perception. So I think that's the other thing. It's not an easy thing, but we have to be mindful of, because, again, technically this board is, constructed in essence to serve the public. So from that standpoint, I think that's the other thing we have to be mindful of. But I think the other key piece too is that it's interesting, because if you look at it, is this document, I've reviewed it so many times with the, in different iterations, but it does provide, for example, opportunities about, attending meetings and, and discussions. So long as the meeting is informal, board members, even amongst themselves. But again, the key thing is no commitment relating to a vote on the matter. I think, those types of things. And so I think it's a good guidance document, but I think there's a law, but I think there's the other part that I think at the same time, it's just being mindful of the public perception.
There was another document I found on OIP's website, Chelsea, and I didn't want to bombard you and the board with adding yet another document to the folder, but there's a Sunshine Law Options to Address State Legislative Issues and Measures document dated August 2022. And so that really drilled down in like 6 pages. It went at length for 6 pages about the permitted interactions allowed under 92-2.5 with a slant towards the legislative session. So it gives 7 different options of how boards can address the legislative session. But I think, as Danny mentioned at the beginning of the meeting, the main one is to either delegate to the hearing, to the executive officer, or to have a permitted interaction group. And I think it works well running it through the executive officer. But again, that August 2022 document is available because other boards struggle with it, subject to the Sunshine Law during the legislative session. Anything else?
I think that's a nice overview. Any questions? And I think if in doubt, you can contact, Ms. Fukunaga, and she can run it by Deputy Attorney General. I'm happy also to answer, any questions, related to the process. And again, the document on Sunshine Law is actually, I think, really helpful because it does indicate what permitted interactions are. And And I think the document that the Deputy Attorney General referred to, I think is actually another good template. Because like anything else, a lot of us wear multiple hats. And then we take care of patients too, right? Patients will have questions. And that's the group in particular we have to be really clear on, that when we're speaking to them, even if we have multiple hats, we're really speaking to them as a physician. And so, I'm not saying anything we already don't know, but again, it's just the challenge of wearing multiple hats and then volunteering to serve. It takes time, right? All the materials we read through and all the things that happen, right? And this is out of our own commitment to, public safety, really. So.
And I know everyone's trying.
Which is why we take an oath. We have to, every time we get on, we take that oath, right? Because I guess they hold us to a different standard, or a higher standard maybe. Any other questions? All right. Yeah, Dr. Ignacio.
I was just skimming back on the documents in terms of like how do you keep up with the legislative session during the board meetings and such. And am I allowed to just, I'm not even sure I'm allowed to say this, but I'll just ask, if I have questions about perspective on board-related legislation, am I permitted to call you up on the board and say, like specifically if it has to do with licensure, for example, and it's related specifically to surgeons or specifically to OBGYN, am I allowed to call the members of the board and just ask them what their thoughts are on this?
So you mean like kind of like the straw poll concept?
Exactly, and not like, oh, how would you vote on it, but like just a discussion about their perspective, and it would be not in the meeting though. So is that permitted?
So I think it's in there, under what the Deputy Attorney General said about permitted interactions.
It is permitted.
So it's a two board members concept. They can discuss board business, outside of a meeting, so long as I think there's certain provisos. No commitment to vote is made or sought, basically, I think. And that, and I think it was really raised by the Deputy Attorney General that in our case, two members don't constitute a quorum of the board. Otherwise, because the conjunction is or, that would be prohibited. But because two members do not constitute a quorum for our board, then two board members may discuss business outside of a meeting. But again, the key is no commitment as to a vote,
Right.
So, and then I think the other thing too is that, the key thing is, I think there's a proviso, and you can correct me if I'm wrong, but as well. But the issue about this continuous, or I think it's a serial communication to through multiple one-on-one meetings, I think that that's something that's I guess frowned upon.
Right, there was, I think it involved the city council where two or more members met and discussed, and then one of those two persons then had a two-person conversation with another city council member. And the OIP said, that was defeating the purpose or the spirit of the Sunshine Law by having a series of two-person conversations. So, as you said, it's discouraged, and we really, should run it through the executive officer. She'll put it on the agenda. All the members can participate. It can be educational and informative and robust in that manner.
Actually, you know what? I opened up the documents that Chelsea put in our folders. So here's the exact language. So the language is much better than I could convey. But what it says is Nevertheless, it would be a serial communication contrary to the Sunshine Law for a board member to discuss the same board business with more than one other board member through a series of one-on-one meetings. Yeah.
So in that sense, and I'm not trying to, I promise, I'm not trying to, I just want to make sure I don't.
Oh, no, I know. You're
Is-
information gatherer, which is a great thing.
I think I understand this to be like, that sounds to me when you're like going to each person, that you are being solicitous of a specific, you have a motivation and you have a goal in mind, and that it's like lobbying. So that in that sense, it sounds more, obviously that would not be acceptable. And I guess what I would say is that if it's permitted, then in the future, what I would do, if I need perspective, is to CC this with Dr. Takanishi and Chelsea, any communication where I'm asking. That way, you can stop me if you think this is over solicitous and defeats the purpose of the spirit of the discussion. Sometimes I'm just seeking clarity on something, but I also want your perspective on it. I certainly hope that I'm not like trying to press a specific idea on everyone. So maybe that's the safest way I can interact, is to do something like that. Because at first I thought, well, if I just call, but that's probably not going to work, because it's better if it's a witnessed interaction.
But, I respect that, because it's, one of the first things to manage potential real or otherwise, potential real conflicts of interest is in essence true the same process you described, right? Your concern is you have questions, but you realize that you wear multiple hats. So you're just seeking clarity, I think, in terms of going through this process of information gathering. So I think, the safest thing is it never hurts to go directly to the executive officer. Because I do know that the executive officer, the deputy attorney general, over the years, they communicate multiple times in a week, if not at least every day. It's just the nature of governmental and commission and board work, yeah.
Thank you.
But great questions. So any final questions for our Deputy Attorney General? And I'm being mindful because in 4 minutes, this sunsets. According to Sunshine Law. All right, I think, and correct me if I'm wrong, Ms. Panak, I think we've covered all the business that's on our agenda.
We did.
So the next meeting is in March, as you can see, and there's information there. And so at this point, I don't think I need a motion for adjournment, because if not, in 3 minutes, this meeting will be adjourned anyway, whether we move or not. So just want to say thank you, and thank you to your Deputy Attorney General for providing that nice overview. And I would keep those documents. They're good to refer to because they're pictorial if you have any questions. Okay, any final comments before we adjourn? Okay, thank you very much, everyone. We'll see you in March.
Thank you.
Thank you, Chair.
Mm-hmm.